All right, Mr. Campos, you may begin.
I'd like to begin, Your Honor, by saying that these processions are extremely stressful. I am pro se. My wife is requesting that I pay attorney fees, and she's failed to mention that I have not been pro se the whole time, and I have had to pay $9,850 in attorney fees myself. And I believe that we should each be responsible for our own fees, as she has independently sought her attorney. Your Honor, the petitioner seeks relief which this court is not constitutionally authorized to grant. I, as a respondent, request this court strike that relief requested, which infringes upon my fundamental rights and is more restrictive than necessary to achieve legitimate state interests. Now, strict scrutiny review is made up of 5 distinct elements of tests that the state must pass before the state has constitutional legitimacy to act on petitioner's request. Parents asking the state to deprive the other parent of fundamental rights do not get a pass on constitutional scrutiny, nor can the state pass the ultimate burden onto the requesting party, as the 14th Amendment does not limit the requesting party, it limits the state. Those 5 elements of constitutional tests are the burden of proof, which I think is obvious that Ms. Martinez has failed to meet, a compelling state interest, a necessity for state action, necessity to act, narrow tailoring or precisely drawn statute, and the least restrictive means. And I don't believe that anything less than 50-50 custody is the least restrictive means possible to achieve what is in the best interest of our children. Mrs. Campos, in conjunction with her attorney and her efforts, are attempting to deceive the court. The best interest of the child standard and legislative mandate alone is sufficient as a predicate for infringing constitutional rights or a compelling state interest to support infringement of fundamental rights. The U.S. Supreme Court specifically held the state's regulation of domestic relations is subject to constitutional limitations. The fundamental rights.
So we can get a record, please.
Yes.
Going too fast again.
My apologies. The fundamental rights of children in these proceedings cannot be infringed any more than fundamental rights of parents can be infringed as the consequence of parents making the constitutionally protected choice regarding marriage, to never marry or to divorce. These choices are individually constitutionally protected privacy choices, and the rights of parents and children to have associations with each other are individual rights, not a right conveyed through marriage. No, now, I, as the respondent, request this court strike any relief requested by petitioner and her counsel, and that the state unilaterally make any presumption about the best interest of the children, such as there can be only one primary parent, or that the parents cannot both preserve being full and equal parents. Where divorce statutes create 2 unequal classes of parent or 2 unequal classes of child, they violate the 14th Amendment's Equal Protection Clause, where the courts assert child custody jurisdiction solely on the basis of a divorce between parents. The court fails the constitutional test of showing a compelling state interest that is necessary, not optional, to achieve permissible state action regarding care, custody, and control of the children whose parents remain fit. Parental rights are derived from the U.S. First Amendment rights of association, with the right of family association receiving the most protection of all types of association. These rights are individual rights that attach to each parent and child equally. These rights do not in any way derive from the marital status of the parents and can in no way be denied as a consequence of a change in parental marital status. Classifications that impact fundamental rights, such as the U.S. First Amendment family association rights, must survive strict scrutiny review. The only legitimate classification of parents in a divorce or post-divorce proceeding is the classification of fit parents. If both parents in a divorce enter that divorce as fit parents, nothing in the divorce proceeding itself can limit the classification in any way. If the parents are or will be living separately, then a classification possibly exists that warrants a limited state interest. However, any infringement or undue burden placed upon fundamental rights as a result of this classification must survive strict scrutiny, constitutional review. In addition, the decision to divorce and to live separately themselves are protected fundamental privacy choices that may not be punished per SCOTUS case law. Parents have every right to choose to marry, to choose to divorce, or to choose never to marry, and the state is prohibited by the 14th Amendment from punishing the exercise of these rights, even for the benefit of another family member. My fundamental rights or our children's fundamental rights cannot be infringed simply with the consent or a petition to the court from one parent. It is my interpretation that the standards currently used in making and reviewing orders that have effect of limiting the parent's access to his or her children do not reflect the legislative mandate regarding parental access, nor do they adequately respect the scope of liberty interest enjoyed by a fit parent in rearing his or her children. As it stands, the standard practice currently in place by these courts and views limitations on parental access to children and vice versa that need to be supported by evidence upon the fact finder could form a firm belief of conviction.
Mr. You're at 5 minutes. You have 1 more minute since I let Ms. Martinez go over.
So I plead with this court, Your Honor, to look beyond the clearly false identity presented today regarding my capacities as a father, beyond the misrepresentations and attack on my character in lieu of pursuing legal argument, to see the facts of this case, which I believe have made abundantly clear time and again, to recognize that any further deprivation of our children from fair and equal access to both parents is beyond the shadow of a doubt, without any equivocation, unjust and unfair circumstance that should immediately be reversed for the sake of our children and their well-being and the preservation of their fundamental rights. And with closing, I pray that Ms. Martinez, as Ms. Martinez now takes this opportunity or has taken this opportunity to try to usurp or supplant the legal precedent provided today, the facts of this case, that you would look past the smoke and mirrors between the strategically placed intonations of her voice and the pregnant pauses for dramatic effect, to look through all the fodder, to see the facts of the case, the reality that my children not only deserve, but have the constitutional and fundamental right to fair and equal access to their father. And I am a fit father who has fair and fundamental and constitutionally protected rights to access, equal access to them. So, Your Honor, in the best interest of our children, it is to preserve their equal access to both parents and to establish an enforceable order that protects those rights and establishes an equal possession order for both parents. And with that, I conclude my case.
Thank you.